How is a contingent contract defined as per Indian Contract Act 1872? Let's see. A contract to do or not to do something. In a contract, you either do or you do not do. You abstain from doing. It's the same line. If some event, if some event collateral to such contract does or does not happen, we'll come to that. But let us understand what do we mean by event collateral here. In maths, you would have done, you would have come across this word many a times, collateral. What do you mean by collateral? Collateral actually means, like, if there's a line, so there's another line, we call this line as main line and this line as collateral line. Lateral actually means horizontal and co means which is along with the main line. So when one person does something, we call it an operation. When many people do it, it becomes cooperation. So here also collateral means something which is running along with the main or the primary thing. So this main thing becomes the primary thing and this becomes subsidiary or secondary. It becomes secondary. So now what is this main thing? This main thing is the actual contract and this collateral thing is the event. Now this contract is dependent upon this event. This contract will happen or not. Who will decide this? This event is the deciding factor. This contract is based on the event. If the event happens, the contract might come into force. If the event does not happen, the contract might not come into force. So this is how a contingent contract is defined. There's a main contract and that main contract is dependent or based on some event which is collateral. Collateral means something which is secondary, which is subordinate, which is subsidiary. So if this event happens, the contract might come into force. If the event does not happen, the contract might not come into force. I also told you that the happening of the contract might also be based on the non-happening of the event. The example of we playing cricket that I gave you. So the contract depends on happening or non-happening of the event. It can be either way. The contract is based on the happening or non-happening of the event. If there is such a condition, such a contract will be called as a contingent contract. So let's get back to definition again. A contract to do or not to do something if some event collateral to such contract does or does not happen. Contract to do or not to do something if the event which is collateral to the main contract, that is, which is secondary, which is subordinate to the main contract, happens or does not happen. Now let's see some examples. First example is fire insurance. Have you heard about the contract of fire insurance? In this kind of a contract, what you do is, let's say you own a property. It may be a house or it may be a shop or a factory, anything of that sort, and you fear that it might be ruined or destroyed by fire. So what you do is you get it insured. insured against fire. Now the insurance company tells you if your house is burnt or your property is burnt by fire, I will pay you the amount. I'll pay you the amount of loss. Whatever loss you incur, I'll reimburse it. I'll cover it. I'll pay it. So this is a normal kind of insurance, fire insurance contract. Such a contract is also a contingent contract. Now, why is this contract a contingent contract? Because you see, there is a main contract here between you and the insurance company, but this contract is dependent upon the happening or non-happening of the event. What event is that? It is the happening or non-happening of the fire. So fire is the event here. If the fire happens, the contract will happen. The insurance company will pay you whatever your loss would be. But if the fire does not happen, that is, there's no fire at your property, then the insurance company will not pay you anything because you do not incur any loss in that case. But in both the cases, you will pay premium to the company. Even if there's no fire, even if your house or your property does not get destroyed, you'll still have to pay premium. So such a contract is a classic example of contingent contract because it is based on the happening or non-happening of fire at your premises. Next example is sale or return transaction. We've already discussed this in the introduction. I gave you the example of buying jeans from you. So the main contract is of buying jeans. It is based on the event of my mother liking it or no. If my mother likes it, the contract is on. But if my mother does not like it, the contract becomes void. It does not become enforceable. The next example is sale dependent on the carrier. This example also we've discussed. I said goods are to come by a carrier, that is by a ship. So if the goods reach safely the port of Bombay, the contract is on. If the goods do not reach the port of Bombay, there's no way that I can sell them. So the contract is not enforceable, then it becomes void. The next example is contract of guarantee. Uh, uh, I don't think you must have heard this, the contract. You would have heard the normal word of guarantee. What is a guarantee? Guarantee, when I ask the students, they normally say you get the goods replaced. That is guarantee. Okay, that is guarantee. That is guarantee as we normally use it in the normal sense that we use it. In law, what is guarantee? Guarantee is giving assurance that if the product is defective, I will give you a new product. So giving the new product does not become the guarantee. It is the assurance that you get. It is the guarantee. In many cases, when you take loans from banks, the banks ask for guarantee, and they ask for the guarantee of some credit-worthy person, some well-known or a wealthy person. So let's say you go to the bank, you ask for a loan of 1 lakh rupees. The bank gives you the loan on the condition that you bring the guarantee of some account holder of the bank whom the bank knows, or some well-known person in the city, or some big shot businessman. So you bring the guarantee of a big shot businessman. Now, what is the use of that guarantee? That guarantee means that businessman is saying to the bank, is stating to the bank that if there is a default from your side, that is from the person who is taking the loan, if he defaults in repaying the loan, the guarantor will repay the loan. That is, he is giving assurance to the bank that you please give the loan to this person. If he does not pay it, I'll repay him on his behalf. So this is a contract of guarantee between you, between the bank and that third party whose guarantee you've taken. Now, do you think this contract of guarantee is effective right from the day when it is signed, when it is made? No. Why? Because this contract is based on some event. And what is that event? It is the event of default. If you default, that guarantor would have to pay. Till the time you do not default, the guarantor is not liable. He is not required to pay. It is only when you default the guarantor is liable to pay. So the contract of guarantee becomes performable, becomes enforceable only when the original loan taker defaults. So you can see the main contract is enforceable on happening or non-happening of an event. Thus it becomes a contingent contract. Contingent contract is also known as conditional contract. Why is it known as conditional contract? Because there's always a condition attached to the main contract. In this case, we saw that the condition was if your house gets under fire. It's the condition attached. Here we saw the condition was if my mother liked the jeans. Here the condition is that the goods reach the port of Bombay safely. Here the condition is that you default. So in every case, the event becomes the condition. The happening of the event becomes the condition, and thus this contract is also called as conditional contract, because in every case you will have this event. A contingent contract is always based on some event, and that event is nothing but a condition. So this contingent contract is also called as a conditional contract because all contingent contracts have some conditions attached to them.